Thank you, Mr. Chair, and Ms. McCabe, thanks for your testimony today. So I just want to make a few statements. You know, there's been a lot of talk about the Clean Air Act and the Clean Water Act, and I think all of us think that it's been very successful. I think we all love clean air and clean water. People are bragging about their states. I can talk a little bit about my state. Cleanest air, cleanest water, probably in the world. Most pristine environment, probably in the world. Highest standards on protecting the environment at the state level, probably in the world. One of the best records in the world of responsibly developing our resources and protecting our pristine environment. So these are all very important. We all recognize that. But I also think jobs are important. I also think affordable energy is very important. In my state, ironically, the citizens of Alaska pay some of the highest energy costs in the country, in Alaska. And I also, very importantly, think the rule of law and the Constitution is important, which I'm assuming you do as well. And I certainly don't think, there's been a lot of talk about China, this agreement. I certainly don't think that relatively flimsy agreements between the President and China authorize the EPA to do anything that Congress hasn't authorized. Do you think agreements with the Chinese give the EPA authority to take any action that the Congress hasn't?
Senator,
I'm just curious because there's been a lot of discussion about these China agreements. We haven't really seen them, and it seems to be you're almost taking action based on an agreement we have with China. Last time I looked at the Constitution, that wasn't where the EPA derives its authority.
Absolutely not, Senator. That is not why we're taking action. We are taking action under the Clean Air Act.
Okay, good. So let me get to another concern of mine. And I just want to get that China agreement issue off the record, on the record, in terms of where you're deriving your authority. One of the things that I've had a concern about, I think a lot of Americans have had a concern about, is what I call the Obama administration two-step. And it goes something like this. The President, his administration want to get something done. That's laudable. The elected President can certainly lay out a vision. A lot of these, though, require actions by Congress under the Constitution. The President will do a head nod to the Constitution, to the statutes with regard to what he wants to get done. And then if that doesn't work out, he ends up taking executive action anyways. There's numerous examples. Immigration's one. President wanted the Congress to move on immigration. Congress didn't. Okay, that's the way the system works. 22 times he says he can't take certain action, then he reverses himself and says, nah, I can take that action. ANWR, that's very important to my state. There's no doubt that the 1002 coastal area, you're probably familiar with it, in Alaska, in order to designate it wilderness, no doubt that has to be done by Congress. President supposedly is going to put forward a bill to do that. It'll go nowhere in this Congress, and yet he's already said, but I'm going to move forward and designate through executive order, I'll manage ANWR for wilderness anyways. The waters of the United States. Again, EPA wanted to expand its authority over the waters of the United States, put forward legislation in 2009, didn't go anywhere because Congress and the American people didn't want you to expand that authority. So through a regulatory action, you expanded the authority. And now you're doing this. And I think the chairman has already laid out that what you're trying to do was try to move through Congress, didn't pass, okay? That's the way our constitutional system works. But it doesn't work for agencies to then say, well, it didn't pass through Congress, so I'm going to do it anyways through a regulation. That's not how the system works. And your agency, in my view, has been one of the biggest abusers of this two-step approach. But it's not just my view. Are you familiar with the recent utility air regulatory group versus EPA decision by the U.S. Supreme Court?
Yes, I am.
Did you read that decision?
Yes, I did.
So it was a decision in which the EPA, or the Supreme Court, was also chastising the EPA for taking actions and authority that it clearly said it didn't have. Let me read a provision of that recent Supreme Court decision. It says EPA's interpretation is also unreasonable because it would bring about an enormous transformative expansion of EPA's regulatory authority without clean congressional authorization. Do you think this rule brings about an expansion of your regulatory authority?
The rule that we're talking about here today.
Correct.
Senator, if I could respond.
No, just respond to that question.
I believe that the rule we have proposed and that we're going through comment on today is squarely based on our authority in the Clean Air Act.
What provision of the Clean Air Act?
Sections 111B and 111D.
Have you read the CRS analysis of your authority?
I'm not sure exactly what
The
you're
Congressional
referring to,
Research
but
Service did an analysis of your authority on this regulation and the questions CRS had with regard to your authority to issue this reg. Have you read that?
I don't believe that analysis suggests that we don't have the authority to do what we're doing.
It looked at a number of areas where it raised questions. I would ask, if you haven't done that, if the EPA, your general counsel's office, can respond to the CRS analysis of this regulation and your authority under the Clean Air Act to issue that. Can you do that?
We'd be happy to do that.
Okay. Now let me get back to the question on what the Supreme Court mentioned. It mentioned when the EPA undertakes a reg that has that's an enormous and transformative expansion in its regulatory authority, they're very skeptical of your power. Do you think that this regulation dramatically expands your authority?
I do not.
You don't?
I don't. I don't. I believe that we are following what the Clean Air Act requires. This is a statute that Congress enacted to protect public health from air pollution. The agency, over a number of years, on a very sound scientific record, has made a determination that CO2 endangers public health and welfare. That determination was upheld by the U.S. Supreme Court, and the EPA then has taken actions based on that finding of endangerment.
I think you're doing exactly what the EPA reprimanded you from doing in its recent Supreme Court case, where you are taking significant power under the Clean Air Act, that's dramatically expanding it, that's dramatically expanding your powers of the U.S. economy without clear congressional authorization. As a matter of fact, you've tried to get this authorization before and Congress has not passed it. Then you're not allowed to then move forward with the regulation to do what Congress won't allow. Let me ask another question. You've talked a lot about the state's flexibility. Sounds great. Sounds wonderful. 32 states have raised legal objections to this rule. 32. 12 have already sued you, even though you haven't finalized it. There was a testimony by FERC Commissioner Tony Clark who stated, quote, "The proposed rule on existing plants has the potential to comprehensively reorder the jurisdictional relationship between the federal governments and the states, dramatically altering the traditional lines of authority." He later said, in spite of EPA's promise of flexibility, states are ceding ultimate authority to the EPA. Do you think that shows flexibility towards the states?
I don't agree with the way Commissioner Clark has characterized it, Senator. The states are clearly in charge of developing plans to reduce carbon emissions under the Clean Air Act and under our proposed rule.
Mr. Chairman, my time has expired. I have several additional questions that I'll submit for the record, particularly as it relates to interior Alaska, communities such as Fairbanks that pay enormously high energy costs and are going to be severely, negatively impacted by this rule if it goes through, and I'd like the EPA to specifically answer questions as it relates to communities in Alaska.
I'd be happy to answer your question.
Thank you.
Thank you.
Senator Sullivan.